there are three wings of the state. First is the legislature, second is the executive, and third is the judiciary. So there's a doctrine of separation of powers. So doctrine of separation of powers was propounded by Montesquieu. So what does the doctrine of separation of powers convey? That the three wings, that is the legislature, executive and judiciary, they shall be separate, and that separation shall be watertight. Now, in a presidential form of government, this doctrine is visible more substantively. Let's take the example of US. It's a presidential system. The secretaries are appointed by the president himself, and they can be dismissed anytime by the president. But if we take the case of India, the watertight separation is not visible to the degree it is visible in a presidential system. Why so? Because in India, the executive is itself taken from the legislature, and there is no watertight separation as such if we go by strictly the doctrine of separation of powers. Article 75 clause 3 of the Constitution itself provides that the ministers shall be collectively responsible to the House of the People, that is Lok Sabha. Now these ministers are none other but the persons who are taken from the legislature itself. Though we have incorporated the doctrine of separation of powers, but not in the true essence as is visible in case of a presidential system, which is more substantive in nature. So as we all know that Article 50 talks about the separation of executive from judiciary. Now, in furtherance of the implementation of Article 50, the Code of Criminal Procedure 1973 was enacted. So what happened was that all the powers of the executive magistrates were withdrawn and were exercised by judicial magistrates, clearly manifesting the doctrine of separation of powers in a modern democratic state like India. That's a doctrine of separation of powers. Now, what is judicial review? So judicial review as a concept has originated from the US Constitution. Now, as far as India is concerned, what is judicial review? It is the power given to the High Courts and the Supreme Court, wherein any law which is inconsistent with the supreme law, that is Constitution of India. So any law or any provision of any law which is inconsistent with the provisions of the Constitution of India will be declared as void and unconstitutional. Now, as far as fundamental rights are concerned, the power of judicial review is inherent under Article 13 Clause 2 of the Constitution of India. But as far as other provisions, other laws are concerned, the judicial review is inherent under Article 32 and 226 in case of Supreme Court of India and High Courts respectively. Now, what are the essential features of judicial review? So while applying the doctrine of judicial review, certain principles are to be kept in mind by the courts of the land. The very first principle is that ordinarily, if there are two interpretations to a law that has been laid down by the legislature, then the judiciary shall go with the interpretation which goes along with and is consistent with the constitutional interpretation of that very law. That is to say, that if there are two interpretations to a law that has been laid down by the legislature, if the first interpretation is in conformity with the constitutional provisions and the second interpretation is not in conformity with the constitutional provisions, then the judiciary will go with the first interpretation that is in conformity with the constitutional provisions and will declare the law to be constitutional and completely valid. The very second principle is that ordinarily the judiciary shall not pronounce on the validity of a law which has not yet attained legal enforceability. Once a law is legally enforceable, it is advisable that only judiciary then pronounces on the validity of that very law. The very last and significant principle of doctrine of judicial review is that ordinarily the judiciary shall not pronounce a law to be legally invalid or void by itself, that is suo motu. It shall only pronounce on its legal sanctity or its validity once that particular law or any of the provisions of that law are challenged before it. So the judiciary should ordinarily pronounce on the validity of a legal provision or a law only and only when a petitioner approaches the courts of law challenging a particular law. So as a concept, judicial review is very relevant and necessary. It's a sine qua non for preserving the constitution, for preserving the constitutional supremacy, for preserving the fundamental rights, for protecting the fundamental rights, and for creating a balance between the three organs of the government. Therefore, doctrine of checks and balances also comes into picture. Doctrine of checks and balances is again a corollary to the doctrine of separation of powers. If one wing of the government is trying to be authoritative in nature, there are provisions in the constitution itself which keep a check and balance. So in Kannada Dasan versus State of Tamil Nadu, the Honorable Supreme Court of India has gone on to hold that the Indian Constitution very well incorporates the doctrine of checks and balances. Why so? Because if one wing of the state exceeds its authority, there must be a check and balance within the Constitution itself so as to maintain the very supremacy of the Constitution, the very fabric of the Constitution. So after discussing these very basic terms, we'll be dealing with the amendability of fundamental rights, what are fundamental rights, and other features of the Constitution of India in the forthcoming lectures. I thank you all for your valuable time. Dhanyavad.